Just as a husband might overlook to amend the will adding his new spouse on marriage, a parent often overlooks to amend a will upon the birth of a child. An afterborn child is sometimes omitted from the will. There are other situations where a child can be omitted though. Of course, the omission could be intentional. Sometimes the parent loses touch with the child and is under an erroneous belief that the child is deceased. The California Probate Code provides for the omitted child as well as the omitted spouse. An afterborn child takes what he would take if there was no will, if the parents died intestate. Similarly, a child omitted due to the erroneous belief of the testator that the child was deceased also takes what he would take if there was no will. There are some exceptions to the general rule that the omitted child takes as if the will did not exist. Firstly, the child does not take if the testator's intent was to omit the child, and the intent was evident in the will. Again, the intent of the testator is respected by the probate court. The omitted child does not take if he is one of several children, and substantially all the estate is devised to the other parent of the omitted child. The other parent is able to provide for the omitted child and the other children in her own will. The omitted child does not take if the child is provided for via a trust or another source in lieu of the will. Otherwise, this will be a situation of double dipping. As with the omitted spouse, if the funds must be taken from the other beneficiaries to satisfy the allocation to the omitted spouse, the funds are taken from each beneficiary on a pro rata basis. Each beneficiary loses the same percentage. Again, specific gifts can be exempted, and the wishes of the testator that a specific beneficiary receive a specific gift can be respected by the probate court.